All right, well, hey, let's go ahead and get rolling. So, good morning, Texas, and welcome to another exciting edition of Listening to an Attorney Talk for the next hour on none other than deed restriction enforcement. So, we've been doing kind of a 101, 201 series on a variety of topics. So, 101 is more of a broad stroke discussion for some of the newer managers, or just simply as a refresher. 201 digs down deeper into some of the big issues that community managers and board members face on a day-to-day basis. So today is our 201 as it relates to Chapter 209, Deed Restriction Enforcement Letters, number one, and then number two, going into the attorney process and kind of what that means when a file goes from being at management or a self-managed association over to the law firm for deed restriction enforcement. What happens? So those are the topics we're going to be hitting on today. As Mr. Beam mentioned, if y'all have any questions for me, please feel free to type them in. As we go along, Kyle may interrupt me, which is okay, to ask the question. And then, of course, at the end of the presentation, I always try to leave 10 to 15 minutes available for typical Q&A. So let's go into a little bit about who I am. My name is Clint Brown. I am a shareholder with the law firm, Roberts, Markel, Weinberg, Butler, Haley, and I actually lead the Property Owners Association division for our law firm statewide. I'm board certified in Property Owners Association law and in residential real estate by the Texas Board of Legal Specialization. What does that mean? I had to take some tests. I've got to have extensive experience in the area. I passed the tests. The state bar says, hey, Clint, you can have these designations, and it means that I am kind of a specialist in these areas of the law. So it's what I eat, drink, live, breathe. Why? Because I love community association law that much. So I'll do my best to keep everybody engaged. And again, as questions pop into your head, feel free to type them in, and Kyle will be managing that as we progress. So I'm an attorney. Got to give the old attorney disclaimer. The information presented today is based on the law as it exists today, June 14th, 2022. And it's also being presented for educational purposes and does not constitute legal advice. If you need that legal advice, please be sure to consult with your attorney. It may be our law firm, it may not be our law firm. That's okay. But please consult with your attorney if you need legal advice. Again, I understand I may be getting a few hypotheticals, got some air quotes there, and that's okay. But remember, educational purposes only, and don't rely on my advice. So, as I mentioned, here's the agenda we're going to be talking about today. We're going to go into kind of enforcement authority. Where is our authority to enforce our deed restrictions? How do we get from point A to point B? And then we're going to get into kind of the 209 letter, the authority around the 209 letter. What are the requirements? And then finally, we're going to delve into the procedures on law firm action. You know, the matter gets referred to the law firm. What takes place? What happens? So let's get into it. All right, so source of authority to enforce our deed restrictions. Your authority is going to be located in your governing documents. 99% of the time, it is your declaration that gives you enforcement authority. If your declaration is silent as it relates to enforcement authority, there is case law and some statutory guidance that we can use to get us from point A to point B to enforce the deed restrictions, as long as the community association is reasonably related to those deed restrictions. Again, it's a little bit trickier of a situation to be in, but work with your counsel to come up with a game plan so that you can effectively enforce your restrictions for the community. But again, as I mentioned, 99 point some odd % of the time, your enforcement authority is in your deed restrictions or your declaration of covenants, conditions, and restrictions, your declaration of condominium regime, your CC&Rs, all terms of art that mean the same thing, your deed restrictions. So 209.006 of the Texas Property Code lays out the requirements that your management company, or you, if you're self-managed, have to comply with before you do certain things. And let's go through this. The association or its agent must give proper notice to an owner before an association may suspend an owner's right to use a common area. So you want to suspend an owner's pool privileges because they failed to mow their grass. It is not automatic. You have to send a 209 letter and warn them you're going to suspend their pool card or pool privileges if they don't mow their grass by date certain. Got to give proper notice before you file a lawsuit against an owner other than a suit to collect assessments or foreclose under an association's lien. So there's another section that governs 209 collection letters. So you've got to give proper notice to an owner before you charge an owner for property damage. So owner damages, again, let's use pools, damages some aspect of the pool or a component associated with the pool. You've got to send that letter before you can charge an owner for that damage. And then finally, you've got to send this letter before you levy a fine for a violation of the governing documents. The notice. And finally, one other thing that's not mentioned right here, we'll mention it in a second. You've also got to send the 209 letter before you send the account to the association's attorney for enforcement action, unless certain exceptions apply. But the general rule of thumb is before you refer it to the attorney, you have to send the letter. And I think we had a good question pop up that's right on point, so I'll address it very quickly. Does the management company send 209 30-day letter, or does the attorney send? The management company is the agent that sends that letter before it gets sent to the attorney. Now, there are some instances where the letter doesn't have to be sent and the attorney provides directly to, or proceeds directly to suit. We'll talk about those instances in a minute, but again, general rule of thumb, management company, or if you're self-managed, association, sends the 209 letter, gives 30 days usually, and then refers it to the attorney after that 30 days has elapsed. A law firm can send a 209 letter, deed restriction enforcement letter, on behalf of the association, but the cost associated with that letter cannot be charged back to the owner. That's what the law says. So you have to understand that it is going to be a cost that the association has to bear. All right, so again, before you do any of these things, you need a 209 letter. That includes fining. So if you want to fine somebody, you have to send that 209 letter first. Let's get back into it. The notice must. Let's go through what the notice has to have in it. First thing, it's got to describe the violation or the property damage that is the basis for the suspension action, charge, or fine. I'm going to continue on with the pool. So element number one, the letter needs to say, hey, you have violated the deed restrictions by not properly mowing your grass. Number two, you've got to state any amount due the association from the owner. As of the date of this letter, your account balance is X. Number three, you've got to inform the owner that they are, number one, entitled to a reasonable period to cure the violation and avoid the fine or suspension, unless the owner was given a reasonable opportunity to cure a similar violation within the preceding 6 months, or unless the violation is uncurable. And then finally, the owner, you've got to tell them they are entitled to request a hearing pursuant to section 209.007 on or before the 30th day after the date the notice was sent by the association. The notice also has to indicate, and there's specific wording that you find in 20906, but you've got to basically say, hey, you may have special rights if you qualify under the Service Members Civil Relief Act. So again, you've got to describe the violation, you've got to lay out the fine amount, the property damage amount, or the fact that you're about to suspend their amenity access, i.e. pool privileges. You've got to state any amount due the association, and then you've got to tell the owner that they're entitled to a reasonable period to cure the violation if it's curable, or unless they've been given a similar letter within the preceding 6 months. You also have to tell the owner they've got an opportunity to request a hearing on or before the 30th date after the date the notice was sent by the association. And finally, they may have certain protection rights if they're serving on active military duty. All right, so before we go any further, I've got some new questions. First one, if the governing documents say that the rights to the common areas will automatically be revoked upon a past due balance, does a 209 letter still need to be sent? Yes, because state law controls over your governing documents, and state law says before you can suspend amenity access, you have to send this 209 letter. So you've got to send that 209 letter with the suspension of amenity rights. Didn't new 2021 laws change 30 days to 45 days? Very good question. So the increase from 30 days to 45 days applies to collection 209 letters. We are dealing with deed restriction enforcement 209 letters. So we are still dealing with the 30-day to request a hearing rule. Now, here's the tricky thing with 209 letters as well. There are really two time frames you've got to think about. One is statutory and the other one is reasonable. So let's go through that real quick. The statutory requirement is 30 days to request a hearing, and it says 30 days, no ifs, ands, or buts. So you've got to use 30. The other time frame is the reasonable period to cure. Most of the time you put 30 days as the reasonable period to cure. Why? Because 30-30 is a lot easier to manage, right? You've got 30 days to cure the grass, failure to mow the grass, and you've got 30 days to request a hearing before the board. Very easy to do and easy to implement. Now, does it have to be 30 days for the reasonable period to cure? No, it does not. It can be less, depending on the circumstances. It all depends on what you consider reasonable. There may be instances where you only want to give them 15, 10, or 5 days to cure. And that can be some of the more egregious violations that you're having to deal with. But keep in mind, when you change the 30 to a lower number, number one, you've got to meet the reasonable standard. It's got to be a reasonable period of time. And then number two, you've got to remember there's still the 30-day rule to request a hearing. So reasonable period to cure, 30 days to request a hearing, two time frames that we are dealing with in the letter. All right. Does an HOA need to send a 209 letter for a force mow? No. So force mows technically don't meet the requirements to send a 209 letter, period. So do you have to send a 209 letter to force mow? No, you do not. Follow your force mow restrictions, period, end of sentence. And regardless, belt and suspenders, it's not a bad idea to send one anyways. But again, some associations don't want to do it. Do you legally have to do it? Assuming your governing documents give you the right to force mow, so enter an owner's property, mow the grass, and charge them back, then the answer is no. Technically, it does not fall under the 209 requirements, 209.006. Next question, can the HOA charge the owner if the management company sends the letter? So it is a cost that gets charged? Can it get passed through to the owner? Yes, assuming we've got sufficiently worded governing documents. So again, you've got to look at your governing documents in that instance, but can you charge back the owner for the cost of a 209 letter? Typically, the answer is yes. How is the date? How is the date the notice is sent determined? Postmark. Association has to inform them of their right to request via certified mail a hearing. Yes. And again, we've gone over these letter requirements previously, but yes, you have to send it certified. And I recommend regular mail as well. How does self-help fit in with this? So that's the force mo. Force mo, self-help, interchangeable, more or less terms of art. It's the ability of the association to enter a owner's lot to perform maintenance on the property. There is no state right to do that. It's got to be located in your governing documents. So self-help remedy needs to be in your governing documents in order for you to be able to use that remedy. If you don't have it, you can't use it. All right, hearings. And again, we spent a lot of time on this for our previous 201, so I'm not going to spend much here. If you want something more in depth, I recommend you listen to that recording. It either already is or will be soon posted on our website. It's got to be scheduled not later than the 30th day after the date the association receives the request. It must be sent to the owner. The notice of the hearing must be sent to the owner at least 10 days before the hearing date. It's got to have the date, time, location, all that good stuff. It's got to be before the board. It can no longer be before a subcommittee or a committee of the board. So it's got to be before the board. And again, here's the specific wording, and at least 10 days before the hearing, you've got to provide them with a packet containing all of the documents, photos, and communications the board intends to introduce at the hearing. And if you do not provide the packet, the owner gets a 15-day automatic postponement of the hearing. And then when you go to the hearing, the board presents their quote unquote case in chief first, and then the owner is entitled to present his, her, or their case in chief. All right. Again, a little bit more on hearings. One postponement each is permitted for a period of not more than 10 days. So something happens, the association has to move the hearing. We are by law entitled to postpone that hearing for up to 10 days. Owner, for whatever reason, cannot attend the hearing. Day before hearing, they say, I can't attend, I need a postponement. They are entitled by law of a postponement of up to 10 days. Additional postponements can be granted as long as the parties agree. And then finally, and the association or the owner are entitled to record, audio record the 209 hearing meeting. All right, so here is kind of that exception I was talking about earlier when you do not have to send this 209 hearing notice. Number one, if there is a lawsuit filed seeking what is called a temporary restraining order or a temporary injunction. If a lawsuit is filed that includes foreclosure as a cause of action. And then finally, either party may file a motion to compel mediation. And then for a temporary suspension of a person's right to use the common area, i.e. pool, if the suspension is the result of a violation that occurred in a common area and involved a significant and immediate risk of harm to others in the subdivision, then you can immediately suspend amenity access. You do not have to send that 209 letter. So this is when you do not have to send that notice and you do not have to provide the right to a hearing. These are the exceptions to the rule. All right, 209.008, attorney's fees. This is a Important topic because we've got to make sure that attorney's fees are linked up to the account. So the association may collect attorney's fees and costs for enforcing the governing documents, i.e. attorney's fees related to deed restriction enforcement, if the 209 notice is provided and the 209 notice expires without a hearing and the violation is still ongoing, number one. Number two, the owner does not timely request a hearing and the 30-day period expires. Number two, if we do not send the letter or you incur attorney's fees before the conclusion of the hearing or opportunity to request a hearing, the owner does not have to pay those attorney's fees, period, end of sentence. So keep that in mind. If you're engaging with your attorney during the period the 209 is still active, or if there is no 209 that has been sent, an owner is not liable for those attorney's fees. Those are fees the association has to bear. Again, we've got exceptions here: the temporary restraining order, the temporary injunction, foreclosure. Those are the exceptions. But the general rule of thumb is you've got to send your 209 letter first, and you have to let it expire and the request for hearing to expire before you start engaging attorneys to levy attorney's fees against the owner's account. Again, you can engage with your counsel during this hearing process before the 209 letter gets sent. There are instances when you have to, because it is such a unique situation. There are times when you have to engage with counsel. Just keep in mind that those attorney's fees cannot be passed on to the owner. And quick sidebar, I think I mentioned this at the beginning, but I want to make it clear. We are dealing with a single family communities here. We are not dealing with condominium regimes. This is all single family type language. Condominium regime, very similar language. It's called a Chapter 82 letter. It's just not as involved as the Chapter 209 letter. All right, got a couple more questions here. What if the owner disagrees with the board decision after the hearing has already taken place? They can disagree all they want. They've had their legal entitlement to a hearing. And if the board wants to proceed with the next step and refer the account to counsel for enforcement, the board can. I mean, you've complied, you've given the hearing, they don't like the results of the hearing. It is what it is. Before the 30 days is up, if an owner files bankruptcy for past due assessments, are all costs uncollectible when the bankruptcy is discharged? Boy, oh boy, this is a bit of a sidebar comment. What I'll do is we'll put this one aside because it's not related to the 209 letter process. It's a very good bankruptcy question though. So if we've got time, I will address that at the end of today. And if we don't, I include the person that asked the question to shoot me a quick email. What about townhouses? Great question. So a townhouse can be two things. A townhouse can be a condo, or a townhouse can be a single family community setup. What you have to do is you've got to look at your declaration to determine whether or not there is the definition of lot in the declaration. And if lot is defined, then there's a high likelihood that it is a single family townhome community. If, however, it's talking about condominiums and condominium units, or the definition of unit is given, something along those lines, then there is a high likelihood that it is a condo townhome, not a single family townhome. Do notice of fine letters have to be sent via certified mail? Yes, I think the language is verified, but certified is what we recommend. We also recommend it be sent regular mail, so certified and regular. All right, more on attorney's fees. All attorney's fees and other amounts collected from an owner shall be deposited into an account maintained in the name of the association or its managing agent. And then only the board or its managing agent or employees may be signatories on that account. So again, keep that in mind when you collect monies. I think it's pretty much a non-issue for almost every community I deal with. And then finally, D as in dog, on written request from the owner, the association shall provide copies of invoices for attorney's fees and other costs. So again, attorney's fees, we link a matter With the owner, we bill all of our attorney's fees to that particular matter. If an owner requests attorney fee invoices, we give them to him or her. We redact any sort of confidential communications contained within those. Maybe there's some confidential entries that are just for the board to hear. If we see any of those, we redact it. But generally, there's little to no redaction taking place, and the owner is entitled to see the attorney's fees that were billed to their account. All right, procedures. So we've gone through the letter. So remember, the 209 letter applies, and you've got to provide, or you've got to comply with all those steps that we went over. And then once that letter expires and we're dealing with an egregious enough violation, the violation can be sent over to the attorney to handle. I'm going to kick in a little caveat here in a minute on this. It's called the 6-month rule, but let's start going through this. So account gets sent to our office. The account includes all the violation letters, or maybe the final 209 violation letter, and it includes any sort of pictures that are associated with the final letter to show that the violation still exists. So our law firm or another law firm gets that. What steps does our law firm follow? The first step we do is what's called a title search. We confirm that Bob is still the owner, number one. Number two, we also confirm that Bob is still alive. So if Bob may have done what's called an arm's length transaction, it's kind of a handshake transaction where they don't use a title company, and they draft the warranty deed or deed without warranty without getting an attorney involved or title involved, and then they just file it in the county record. So management doesn't know, the county appraisal district may not have picked up on it, and we just have no clue. We get the file, we run title, it pops up in title. So that's one thing we look for to make sure Bob is still the owner of the property. The next thing we do is that we confirm there is no active bankruptcy associated with Bob or the property. I say or the property because sometimes you could have a tenant on the property that files bankruptcy, and they are entitled to certain bankruptcy protections as it relates to the property. So again, we look at all that. That's one of the steps we do. We also confirm that there's no active military status. We also, again, confirm that they're not deceased and that no foreclosure has occurred related to the property, maybe by a taxing entity or by a lender. And then we send our demand letter, our initial demand letter, and our model validation notice. So that's step one. Demand letter demands that they fix the problem within a certain amount of days. It also says, hey, you've been billed attorney's fees in the amount of blank, and more attorney's fees are going to attach to your account. Oh, and by the way, you need to make sure to understand that we're going to seek civil damages if we file suit, and we're going to continue to accrue attorney's fees. Strongly worded letter. The time that we put in there to cure is usually 30 days. We can tighten that time frame up sometimes in certain circumstances, 30, 45 days, general rule of thumb. That time frame comes and goes. What do? We send a notice to the manager and say, hey, manager, does the violation still exist? Number one. And number two, if it still does exist, do we have authorization to proceed with a final demand letter? Manager looks, provides us more pictures, confirms the violation still exists, and confirms that we can proceed with the final demand letter. Our law firm sends the final demand letter. Similar wording, except now we're getting closer to the litigation, so it's stronger in the lawsuit realm. Owner still doesn't do anything. So what do? So right now we've stopped, we've sent our letters, violation still exists. Now they've got attorney's fees attached to the account. What do? So the first question you've got to ask is, are you levying fines against the owner? And if the answer is yes, if you want to continue levying those fines, and we are outside of 6 months from the date the previous 209 letter was sent, the association has to send a new 209 letter to continue fining. And that's based on the wording in the statute. You can only fine for periods of 6 months. So month 1, you send your 209 letter. You fine in month 2, 3, 4, 5, 6 comes. You've got to send another 209 letter if you want to keep on fining. That is how the law is written, so keep that in mind. Every 6th month, send a new 209 letter if you want to continue to fine. If you only want to do it for that first 6-month period, then you're good to go. So one option the association has is to file what's called a notice of non-compliance. Legally speaking, it doesn't do anything legally. It doesn't toll the statute of limitations. So it doesn't stop the statute of limitations from running, which is 4 years. General rule is 4 years from the date you knew or should have known about the violation. You've got 4 years to file a lawsuit. It does not stop that 4-year clock from running. Is it a good practice? Yes, it can be a good practice because it puts the title company on notice that there is a violation. Now, the resale certificate is designed to notate violations in there as well, but sometimes violations slip through the cracks and they don't get listed on the resale cert. So if we've got a notice of non-compliance filed in the real property records, title will pick it up and will require release of that notice. And that's when we get to say, hey, we're happy to release it, but you need to cure the violation. And it's instances where, the association simply does not want to file a lawsuit yet, maybe wants to sit on it for another 3 months. Well, notice of non-compliance may be a good secondary option for you. All right. What if Bob is not the owner? So again, we open our account, we run title, and lo and behold, Bob is not the owner anymore. Now it's Jill. Sorry for all the Bobs and Jills out there today. If Jill's the owner, yes, you have to send a new 209 letter. Do you have to start the process all the way over and send a courtesy notice? No, not necessarily. Why? Because Jill has been getting the notices. Because you've likely been mailing the notices to the property address. So Jill's been getting them. She doesn't get a courtesy notice again. She's likely already gotten it. But you send a new letter addressed to Jill. Once that 209 letter expires, you get it back over to counsel, and the attorney can proceed with their process that I just went over. Now, next question. What if an owner has not been receiving notices for years but currently starts to receive them? Does the statute of limitations apply? The answer is, I'm going to give you an attorney answer. It depends. Different facts, different rules apply. Sometimes the violation resets itself. It's like they cure it and then they violate again. They cure it and they violate it again. So the statute of limitations does not run. There are other instances where you can use what is called the discovery rule, where you really should not have known about the violation, but when you discovered it, maybe in year 4, then the 4-year clock starts ticking. So unfortunately, I could spend 30 minutes talking about that. So again, get with your counsel on specific areas where you may think 4-year statute of limitations may be an issue. Next question, what if docs say fine right away for something like making a major change without getting ACC approval, or strict rules that state no street parking, we want to fine that day? Do we still have to send a 209 letter? Yes, the law trumps. The law controls. Now, there are instances where maybe it is considered an uncurable violation, which means it is not capable of being cured or is a threat to the health or safety of fellow owners and the community at large. If that is the case and it's uncurable, you can fine immediately, but you still need to send a 209 letter. So send that 209 letter. Do we take into account if the mail was forwarded for Bob? So again, more than likely the new owner has been getting these notices. If the address of Bob is off property, then you must send a new courtesy notice to Jill. No, again, not necessarily. You can, assuming your deed restriction enforcement policy, and that's a policy designed to lay out these rules. If we drafted it, you're good to go. But if another law firm drafted it, make sure you review it, because there should be some some leniency in there that allows the board to accelerate directly to the 209 letter, i.e. you don't have to send a courtesy letter all over again. Next question. Recently took over a community where the previous manager was sending them letters for having an Airbnb. Last letter sent was in December, which is titled as a fine letter. However, in reviewing the account, no fine was ever charged. This is the same homeowner that is at the attorney for collections. Do I need to start the process over? Good question. Maybe not. You may be able to combine the collection action with the deed restriction enforcement action. As long as the collection action isn't too far along, I, of course, recommend you reach out to your attorney to get his, her, or their opinion on that. But good question. Can we go straight to a 209 letter instead of 2 friendly notices? Yes, the association can establish whatever deed restriction enforcement policies and practices it wants to, and as long as you're being consistent in your enforcement, i.e. going straight to the 209 letter, that is okay. You can do that. There is no legal requirement to send courtesy notices. Again, a lot of associations like to do it to try to be neighborly and try to get it fixed before you send kind of the 209 letter nastygram. But is it legally required? No. But make sure your governing document, your policy is worded appropriately, and your governing documents don't require a courtesy letter. I don't see that often, but look at your governing documents. All right, all great questions. Let's go on to the next slide here. Okay. So we have sent all of our letters. Management has sent their letters, their 209 letter. Law firm has sent its letters. Maybe it filed a notice of compliance. And now we get approval from the board to file suit on the deed restriction enforcement violation. We've got current pictures, i.e. less than 30 days old, clearly showing the violation. So what the association then does is, or excuse me, the law firm does is draft what's called a plaintiff's original petition. Think of it as the lawsuit, the document that sues the owner for violating the restrictions. And this document has to be verified by the manager or a board member, somebody with personal knowledge of the violation. So there's this verification at the end of the document that a manager signs and or notarizes that gets you covered for the lawsuit. Lawsuit then gets filed, and a third-party company or the constable serves the lawsuit on the owner, who's now the defendant. The owner then has a certain amount of time to respond to the original petition. It's the Monday following the expiration of 21 days before 10 a.m. There's all sorts of different rules, but roughly 21 to 30 days. An attorney can give you an exact date depending on when service was affected on the defendant / owner. Now, hopefully by this time, the owner is going to reach out to the law firm. And if that happens, we encourage resolution with the defendant to avoid further litigation. Look, further litigation is not good for anybody, because the association is going to have to continue to pay attorney's fees to try to get the violation fixed and enforce the deed restrictions. And the owner is going to have to potentially retain their own attorney or fight the law firm as it relates to the deed restriction matter. So getting it resolved is in the benefit of all parties involved. And look, seeking mediation may be a very good way to get it resolved, get everybody at the table, and you mediate the matter. So you've got a third party intermediary, a middleman or woman or they, that interacts with plaintiff, which is the association, and interacts with the defendant, which is the violating owner, to try to meet in the middle. You know, they say a successful mediation is both sides leaving unhappy, but the case was settled. You've got to understand that there's going to be a settlement aspect to it, number one. Number two, let's assume the association has the authority to fine, has sent the proper letters, and has been fining. Fines should be considered a negotiating tool, typically. They're a soft cost, and so the association should use those fines to try to get the matter settled. Now, if there is not an answer filed by the defendant, the association can file what's called a motion for default judgment that basically says, hey, judge, we win by default. They didn't file an answer. And we see those. It's when the defendant is just non-responsive and puts their head in the sand. Well, the association can get a default judgment in that instance. All right, before we go on to temporary restraining orders and temporary injunctions, I've got some more questions. So I've got a property in legal, and it is in regards to a fence that is at the back of the property, side fence, and I'm unable to get pictures. What can I do? Again, you've got to confirm the violation is still existing. Try to get the neighbor to get information, or at least a narrative showing that the fence is in violation for X, Y, and Z. Look, I've had instances where we file a lawsuit, we can't readily see the violations anymore, but we still allege they're there. We go out and do a site visit, and the owner has cleaned up whatever the violation is. And then 2 days after the site visit, the owner basically puts all the violating items back on the property. So I get it. It can be difficult to enforce those types of situations, but you've got to do your best, get with your counsel to come up with some other unique ideas to show that the violation is still there. If a violation has not expired, can the violation be escalated before compliance date is met? I mean, if the 209 letter gives a certain amount of time to fix a violation, and that's the violation that you're talking about, then it doesn't sound like you can. You've got to stick with what you've said. So if the violation letter says you've got X days to cure, you need to give them X days to cure. Can the reverse of default go against the association? If an association is sued and the association does not adequately or timely file an answer, then yes, an association can be subject to a default judgment as well. But in this instance, you know, the association files the lawsuit, so it's the other side that can be subject to a default. Getting back to the procedure, two types of temporaries that we deal with on deed restriction enforcement lawsuits. The first type is called a temporary restraining order. That is the quick fix. It can last up to 28 days. And basically, you're asking the court to direct the owner to stop violating the restrictions or to take some sort of affirmative action to fix the violation immediately. And temporary restraining orders also get you around the 209 hearing requirement, as long as you're going to be filing that TRO very quickly. Most of the time we see TROs when there is a unapproved structure going up, and it's a structure that would not be approved by the ACC, period, end of sentence. So in order to prevent what's called economic waste, whereas, you know, you don't do anything, the owner installs a $40,000 structure, a court's going to be less likely to order the owner to tear down that structure. So when you see the structure and you know it's in violation of the restrictions, you know, and or management has to act very quickly to get it over to counsel, because counsel is going to have to file that lawsuit as quick as possible. And that's where that temporary restraining order comes in. A temporary injunction hearing is down the road, and it's to bring the freeze out until trial. So prevent an owner from doing a violation until trial. Think of it like a mini trial. You're going to have some witnesses typically that you're going to be asking questions on. The other side's going to be able to cross-examine those witnesses. The judge is going to look at evidence that you're going to be able to produce and enter into evidence. And then the judge is going to rule on the temporary injunction request. Again, temporary injunctions last a lot longer. They typically last through the trial or summary judgment, or, if in the event you can get a summary judgment. All right, next question here. Another violation occurs while at attorney. Does a 209 letter need to be sent? Unfortunately, if it is not the same or substantially similar to the violation that is at the law firm, you've got to send a new 209 letter. I know it stinks, but it's a new violation, so send a new 209 letter. If someone installs an ugly handrail because of a disability without ACC approval, can anything be done? Yes, I think the association can take, can take action, but there are protections afforded them under the Fair Housing Act. It may be considered a reasonable modification that we have to allow, the owner pays for. And if it's something that was installed on the common elements, we may be able to take some action as well, because we get to control what is installed on the common elements if we want to foot the bill. So again, get with your counsel on that, but understand there are some federal and state law protections for installing modifications if that person needs the modification, structural modification, due to a disability. So keep that in mind. Does anyone on the board have to be at a court hearing? Yes, there is a likelihood an association board member will need to be at the hearing as a witness. Again, depends on the facts. If there's a board member that has all the factual knowledge and the manager doesn't, then we're going to request the board member be present, potentially in addition to the manager. So it'll be the manager and the board member. All right. So again, temporary injunction, temporary restraining order. We do all of our litigation stuff, and let's assume we get a judgment. So what happens after the judgment? We've ordered the owner to paint their house a neutral color because they painted it bright pink. And the court has ordered them to repaint the house subject to Architectural Control Committee approval within 90 days. Well, we provide a notice of the judgment to the defendant, we abstract the judgment, and then we, wait for our 90-day clock to come and go. 90 days comes and goes. The owner has basically said, I don't care. I'm going to do what I want. What happens? Well, we send a kind of a post-judgment demand that they immediately do it. If they still don't do it, we file what's called a motion for contempt. And it's basically asking the judge to issue a show cause order to direct the owner to show cause as to why they are ignoring an order of the court, because that's what they're doing. There's a judgment that's telling an owner to do something, and if they don't do it, they're ignoring what a court has ordered them to do. So there is this show cause order, and then you've got a show cause hearing. Let's assume the owner shows up and says, yes, I've painted my house neutral, and of course they did not, or they did so in a haphazard manner. And then another hearing may be established or set, and that is called a compliance hearing. So this is after we have our judgment. Now we're just trying to get the judgment enforced. And with that, right at 10 minutes. So we've got 10 minutes now for any question and answer regarding deed restriction enforcement. So I'm looking at the chat, so y'all ask away. Maybe all the questions have gotten asked, which means I did a good job answering throughout the presentation, maybe. All right, so while we're waiting for more questions to be asked, I'm going to, let's see if I can go up to the bankruptcy question. Let's see if I can find that thing. All right, so basically, law firm did some work, some restriction stuff got filed against the account, and we filed it, but then an owner files bankruptcy. So charges were levied against the account, but an owner files bankruptcy. The owner receives what is called a discharge, which means they completed the bankruptcy successfully. Can we still collect those monies against the owner who filed the bankruptcy and successfully completed the bankruptcy, receiving a discharge? Of course, I'm going to give my attorney answer. It depends. And it depends on whether or not the charges are considered secured charges or unsecured charges. If the charges are considered unsecured, that means they don't attach to the property and are not foreclosable. Then no, we cannot collect those monies. They need to be written off because the owner received a discharge of all personal liability that accrued pre-petition. If the charges are secured, that means they attach to the property and are foreclosable against the property, then yes, the charges as to the property remain, but the charges as to the person go away. So Bob is no longer legally obligated to pay those charges, but Bob's property is still obligated to pay. I know it's kind of odd, but it's called in personam liability versus in rem liability. And Mary Shiloh and I did one of my team members at the firm. We did a couple presentations on bankruptcies 101 and 201 with Teddy as well. Teddy Holtz, another shareholder at our firm. I encourage you to look at those bankruptcy presentations. They delve into that a little bit deeper. Let's see if we've gotten some more questions. Here we go. After bankruptcy, does 209 start again? Yes, it does. And we've got some more questions. Can you charge homeowner back for 209 letter and postage? Again, assuming your governing documents allow for that. Yes, you can. Next question. What is the best course of action when there is a property that has individual rooms being rented out like a frat house and the owners keep swapping bankruptcy filings? Man, that's a good question. Again, bankruptcy centered, not really pertinent to this presentation, but I'll say you may be able to pursue relief based on what's called a serial filing. And there's some laws that apply under the bankruptcy code as it relates to serial filers. So please get with your legal counsel. He, she, or they should be able to provide you some advice on whether or not there's some relief based upon serial filings. What are examples of unsecured violations? Popping fireworks, a threat to the health or safety of the community or fellow owners. Property damage is considered an unsecured violation. Let's see what else. A massive party that happened once is considered a uncurable violation. A party that happens every Friday that is not, that's curable, right? It's capable of being cured because it happens every Friday. So those are some examples of unsecured, or excuse me, I was talking about uncurable. The question was examples of unsecured. Unsecured amounts really depend on your governing documents. Many times fines are considered unsecured, but I've got plenty of communities where fines are secured. So again, you've got to look at your governing documents to figure out whether or not it's unsecured or secured. Sorry, completely mixed up unsecured from uncurable. Regarding the fence and pictures, it is confirmed that the law firm has received communication about replacing fixed fence pickets from the homeowner. You mentioned we can request a site visit by the association property manager to obtain pictures. Yeah, so if the owner says, hey, everything's been fixed, but we can't determine whether or not it's been fixed, we can request a site visit to confirm they did what they said they did. Statute period for unsecured and secured liens. 4 years is the statute of limitations for collections. So it's similar to enforcing your restrictions, which is 4 years. And again, on collection questions and bankruptcy questions, we've got some really great collection presentations and bankruptcy presentations on our website. I encourage you to do a little search for them on our website, www.rmwbh.com, our law firm's acronym, and you can find a bunch of educational sources on there in regards to bankruptcy and collections. How many years unsecured judgment? A judgment can last arguably in perpetuity, so forever, but you've got to do certain things every so often. It's pretty much every 10 years. Any other questions? Looks like that may be it. Oh, wait a minute. One more question. We are getting ready to start a storm drainage project in the patio areas of 7 townhomes. The patios are a common area with exclusive use by owners. However, what happens if one of the owner threatens to sue the association so as not to remove stuff from her patio? Boy, oh boy, it's a pretty specific hypothetical there. Again, very governing document dependent, assuming you've got self-help remedies and entry remedies, you've got to do what you've got to do, especially if you're obligated to maintain the patios. So in that instance, it may be wise to get counsel from your attorney so that she or they can kind of guide you so that you're in good shape if the owner decides to bring a lawsuit against you. Perfect. Well, hey, thank you all so much for listening in today. I hope I wasn't too boring and y'all learned a little something on this DRV 201. Again, really appreciate all the participation and the great questions we had today. And I encourage you to participate in future education seminars. With that, I will leave y'all to the rest of your Tuesday, and I hope you enjoy your week and do your best to stay cool. Bye, everybody.